Good afternoon, ladies and gentlemen. You can see me now so that you can at least see or get a picture of the person speaking. But I'm going to take away my picture as I want to share a PowerPoint with you. And as you see, I am sitting at home in my own study. So this is new for me, and I just hope I don't mess it up. So first of all, I have to share my PowerPoint with you, and then we will officially start. We are recording this, but we usually only make available the PowerPoint and not the recording. So let me just share with you the PowerPoint. Let me just, oh, this is all new. Okay, just wait a minute. Let me just go through it quickly. I just want to have it smaller so that I can still see, and there's someone there. Okay. And then let's go to the beginning. Okay. I hope you can all follow me and that you see the PowerPoint. If Bululani, if you can just indicate to me whether you can see the PowerPoint. Let's see. Yes. Can you see the PowerPoint?
We can't see it, ma'am.
Okay. Now? Can you see it now?
No,
We
I
also
can't.
don't.
Okay. Wait, then I'm doing something wrong. Share the
Maybe
content.
we are just as
Okay,
neat
there
as
it
you.
is. Do you see it now?
Yes, we can see it.
Okay, excellent, excellent. Okay, so you've seen me a little bit. I've seen some of you, so I just ask once again, just put your videos down and mute yourself. We can have a discussion later, but if you keep your video on, then it takes too much. I don't know what, but something electronically doesn't work if there's too many faces. So good afternoon. This is the third and the last webinar, and I am excited. This is very exciting as I can see you. I saw some of you at the beginning, so at least I am not just talking to myself. And at the end, you can ask questions and we can have some interaction. Okay, first of all, as I always say in all the webinars, remember that the admin matters. Grace will assist you, and we have done already 2 webinars, webinar 1 and 2, and the PowerPoints are available for you. So today I'm focusing on the last part. You will also see in your study material that at the back of, or the last part of your study material, there are exercises, but we don't provide the model answers as every person will look at the case different and there is no specific model answer for those things. You must work it out yourself. Okay, then I thought, let me just show you what Bonnie looks like and what I look like. My hair are longer now, but yes, that is what your facilitator Bonnie looks like. She used to be my master student. She is excellent in medical law, but at least now you have faces behind the voices or the emails, etc. Okay, then as I also usually say, you must remember to keep an eye on the announcements as we may post interesting things. And remember, you are also welcome to ask questions on the forum. You are welcome to ask for help if you find it difficult. And then the portfolios, I've stressed this now many times that the portfolios is 80% of your final mark. and test 1 is the other 20%, and that will be your end result. And I think by now you know how it works, and you have done quite a lot. I know the last portfolio is still due, but please do your best. And as I've said previously, if you pass this module and you pass it well, you should be extremely proud of yourself, because this is difficult. It's a lot of work, and we expect a lot of you and a lot of extra work, which goes beyond the study guide. So if you pass and you do well, feel proud of yourself, because this is a lot of work in a very short time. Now let's just summarize what I ended off in the previous work, and that is how to approach a medical negligence case. So I said that first of all, you consult with the client and you gather all the facts so that you can see whether there is a course of action. But there, once again, I want to warn you. If you listen to your client or the patient and there's an alleged medical negligence, remember that they will remember the facts as they saw it. In other words, they might not give you all the facts. They might not purposefully hide things, but they may not say everything. And you need to know everything in order to see if there is a course of action. But get as much as you can from the client. And as I've also alluded to earlier, some attorneys send the patient home and say, go and write everything and sort of come back with a file so that you have more time to remember all the facts, because everything is extremely important. Even if they do not think it is important, it might be very important. Now, once you've got your story from your client and you've got all the facts or their version of everything, ask your client what he or she wants. And I told you last time, this is important because that will give direction on where you are going. Does he or she want revenge? Do they want to prove a point to the doctor? Do they just want answers for what happened? Or do they want rand value, damages to be paid out because of the suffering, that they need special attention or their child needs special attention, or what the case may be? But ask your client, because most of the time you will hear that the patient is angry. The patient is angry, first of all, because the operation was not successful. And secondly, most of the time because the doctors didn't talk to them, didn't explain to them what happened. And now they are left with something that went wrong, either for them personally or for a loved one, and they want answers. But if the doctors do not speak to them, they might also be so angry that they want revenge, or they want to sue the doctor because he made a mess. So you need to know, where are you going and what does he or she want? Then you obtain the hospital records or the doctor's records. And as I've said, they will not give you the original. They will give you copies and you will have to pay for the copies. And remember that I said in that book on expert witnessing, which was written by Van der Heever, that book will take you step by step on how to ask for the records or how to obtain the records. And then remember, if it is not written down, it did not happen. So if you get the hospital or the doctor's records and they say, yes, but I did get the informed consent, or yes, the nurse gave the medicine. If it is not recorded, it did not happen. That is very important to keep always at the back of your mind. Then you compare your client's version, and as I've said, that remember, every mishap is not necessarily negligence, but you compare what your client told you to the hospital or the doctor's records so that you can see whether there's an overlap or that you can see how the story unfolds in front of you. Once you've got that and you see, yes, there is a cause of action, remember I said you must be able to prove all the requirements of a delict. So you will test on the requirements of a delict, and now you see, okay, there is possibly a case. Then you need to consult an expert in the field in which the have happened. So either a gynecologist or a surgeon or a neurologist or an anesthetist. You will have to consult one to look independently at your client's version, at the hospital's or the doctor's records, and then to advise you whether something out of the ordinary happened and that the doctor did not act as the reasonable doctor or the reasonable expert in the circumstances, and that expert opinion will give you guidance on whether it is worthwhile building a case, going to court, etc. So that is extremely, extremely important. Also in that book of expert witnessing of Van der Heever, and the same, the LexisNexis medical malpractice in South Africa, and it is written by Sainer, senior counsel. They will show you step by step how to engage with an expert and how to negotiate fees and how to send the documents to the expert, etc. Where do you find an expert? I referred you to the South African Medico-Legal Association. On their website, you will get a lot of experts, or you go to medical faculties at universities. Those professors are also sometimes willing to be expert witnesses. But, and I warn you, it is difficult to get experts because medical people don't like the law, so they don't want to become involved in court cases because they feel their time is wasted, etc. But try to find someone, because you cannot have a successful case, or you cannot even start your case unless you have an expert opinion indicating to you that there is possibly a case. Then you start preparing your documents. And remember, you should sue on the basis of a contract or a delict or both. And remember the difference. If you sue on the basis of breach of contract, you can only claim patrimonial loss. Whereas if you sue on the basis of a delict, you can also claim non-patrimonial loss, which of course is pain and suffering. And then very important, remember the institution of legal proceedings against certain organs of state, where you have to give notice if you are going to sue the state, a public hospital. Remember, in a public hospital, all the doctors and the nurses are employees of the state, and therefore your party against whom you will institute the action is the MEC, the member of the executive committee or executive council of a province, as that person is seen as the employer of the people that work in the public sector. Okay, so that is still a summary of the previous work that we did. And I think you've been through all the work now because you've done test 1 and you've already done your portfolio 1 and you have done your activities. So I think you are now more or less with me on the same page with what medical negligence entails. I want to say this, and I want you to take cognizance of what the slide now states. The High Court rules have changed, and you will find the rules in the Government Gazette, the GG, Government Gazette, of 7 February 2020, and it is Government Gazette number 43000. And in that Government Gazette, it is stated that Rule 41A is now applicable, and it indicates mediation as a dispute resolution mechanism. What does it mean? It means that although it became operational on the 9th of March this year, but then we went into COVID and basically the whole country came to a standstill. But this is the future. In future, any alleged medical negligence case will have to go for mediation first. Same with the road accident fund. They will have to prove to court that they have tried mediation and whether it was successful or not successful, on which points was there an agreement or not, and they have to hand it in court before litigation can start. So I get a lot of questions of students asking me they would love to go into the field of medical law. How can they do it? Okay, first of all, if you want to practice as an attorney in medical law, you need, of course, your LLB, and you need to do your articles to be admitted as an attorney, or you can be an advocate or an advocate with a trust account. You must read the Legal Practice Act to see the new requirements. And one of the new requirements is also that candidate attorneys will have to do community service. So all these things happened after I did my pupillage. So make sure you understand what the Legal Practice Act say now, what is the requirement to become an attorney. So if your passion is for medical law, try and find articles at a law firm who does personal injury or medical law. Unfortunately, they are scarce. There are more of them now since the road accident fund have changed, but that is a way to start, so that you start as an article clerk and then see how it is done with your knowledge that you've gained now. Or what you can also do with the knowledge that you have is go for a course to become a mediator, because there's going to be a desperate need for mediators with medical law knowledge or medical law background. And you have to be an accredited mediator in order to do medical mediation. You can do the training through the University of Stellenbosch, conflict dynamics. They train mediators, or you can also go to the website of the South African Medico-Legal Association. They also do training for mediators. Now, I must admit, I did the training and I am an accredited mediator. I did the training quite a few years ago, but on Monday I was involved. We were a team for the first mediation concerning road accident fund matters. And my experience, that is that last part on this slide, is it is extremely intense. We started at 10 in the morning and we ended only at 6 o'clock. It was intense, but it works. It works because those of you who are already practicing as attorneys in the court, you will know that it is very often that the patient, especially in road accident fund issues, never gets the chance to speak or to talk about how his or her life has changed after a motor vehicle accident. But in mediation, you get that. You can hear the person that suffered the injury and you can hear their suffering. And then on the other hand, you hear the road accident fund with their limitations and you talk to both parties, and eventually, if you are successful, there will be a settlement. But I've spent some time on explaining this to you because what is the way forward with the knowledge that you have now? Think about becoming a mediator, and it helps immensely to have medical law knowledge if you have to mediate medical law issues, because then you will understand what can and cannot be done, or what is the test for negligence, etc. So please keep that in mind. It is something where you can use your skills and your knowledge, but you will have to be trained as a mediator. Okay, now let's go to the work of today. Something I just want to stress, and I don't think I've stressed it enough in the previous webinars. Remember that a doctor never guarantees success. So even if a patient comes to you and something went terribly wrong, or just something small went wrong, remember, medicine is not an exact science, and doctors never guarantee success. And every person might react differently to a specific operation or to the anesthetics, etc. So remember that the operation is never a guarantee of success. And sometimes patients forget that. They think that the doctor said, I will do this and that, and then something went wrong, and now they want to sue the doctor. It is not necessarily negligence. Always remember that, and always remember the test. What would the reasonable doctor have done in the similar circumstances in which the negligence happened? The case that is on the screen, MSM on behalf of KBM versus the MEC for Health in Gauteng. It is a case that was that the judgment was given on the 18th of December in 2019, but it is extremely important, and I honestly beg you to go and read these two cases, because they have changed medical law in a sense, although take note that the first case there is only a High Court decision. The one where it says, remember, is a constitutional court case. But the one in the High Court in Gauteng followed on the constitutional court case. Now, what happened in that constitutional case? Let's first go back to before it went to the Constitutional Court. What were the facts? It is in a public hospital, and there was negligence of the staff, and a baby was born with cerebral palsy. So it went to court, and the MEC for Health was found guilty. Remember, it's not the person, it is the Department of Health. They were 100% responsible for the negligence of the cerebral palsy of the baby, and therefore they had to pay 20 million rand. That was the determined, remember, the quantum that they determined past and future medical expenses and the loss of amenities of life and what this child could possibly have been. So all those calculations were made, and then it was the amount was 20 million rand. But then the MEC went to the Constitutional Court and said, in our common law, there is the principle of once and for all, meaning that when you go to court, you must claim everything once and for all. And that is why we do it in future medical costs and future loss of amenities of life and what this child in the future could have been. You must now determine all of that, and the actuary will do it for you. We as lawyers cannot do these calculations. So the actuary came to the amount of 20 million. But then the MEC went to the Constitutional Court and challenged the once and for all rule and said, why must it be paid once and for all, and why should it be paid in rand, in money? And the court looked at all the facts, the Constitutional Court, and said, depending on the facts of each case, there is a possibility to develop the common law and deviate from the once and for all rule, and not to have the damages paid in one lump sum in rands, but it could also be paid in kind or in periodic payments. Okay, so that is where they ended. And then there was another case, also of a baby suffering because of negligence and cerebral palsy, and they went to the High Court in Gauteng. And there Judge Keithley used the Constitutional Court. What they said in the DZ case, she used it and she developed the common law. So in her judgment, she said that it is not necessarily to pay in once and for all. In other words, you can also have periodic payments, or you can pay in kind. And what she did is she had all the people involved with a cerebral palsy baby, that's a physiotherapist, an occupational therapist, a dentist, surgeons, doctors. She investigated all of them, and then she decided that there shouldn't be an amount in rand for future medical costs, but that the future medical care must be supplied by the public sector. In other words, instead of having an amount for future medical costs, it will be provided by the public sector. Now, it is all fair and well, but remember, this case was only about one child. And she even went further and said that if the child is not getting the attention or the therapy that that child needs, that they can approach her, the judge, in chambers. So I want you to read that case and see whether you agree or not, because there's different sides to it. Yes, 20 million is a lot of money, and one can argue rather give the therapy. But it is not just one baby in our public sector that suffers from cerebral palsy. There are many. And this is a judgment for one child. What's going to happen if there are 50 children? So it is, according to me, not sustainable. And as I've said, it is a High Court case. Maybe it will escalate to the Supreme Court of Appeal. I don't know. I want you to think and make up your mind. Why? Why do I say this to you? Because a lot of attorneys or people that practice medical law works on contingency. Contingency means a success fee. In other words, only when you are successful will you, as the lawyer or your legal firm, be paid. And according to the Contingency Fees Act, with all the detail, I'm just speaking generally now, you can then claim 25%. So 25% of 20 million, as was the case in that High Court case, is quite a substantial amount of money for the attorney. Now the question is, what will happen when it is not paid in an amount anymore, but now through services? It will have a huge effect on contingency fee agreements. And that is why I cannot stress these two cases enough. You have to take note of it because it has an influence on the future, and it will or might influence you if you do work on contingency. Please pay attention to those two cases. I'm just having a sip of water as I'm talking so much. So please remember those two cases. Very important, because that is an indication of where claims might go in the future. Okay, but today we are busy with the grounds of justification. that the defendant can have in a possible medical negligence case. So first of all, when there's medical negligence, the doctor or the hospital who's the defendant can say, but the patient gave informed consent, or they can claim, but what they did to the person was because of an emergency, or they could say what they did is because of statutory authority. For example, they took a blood sample and it is necessary for criminal proceedings, or they had to do certain things because it is a risk to public health. And this is quite interesting. I think we've heard a lot about risk to public health now with the coronavirus. So if there's a risk to public health, then it could be a ground of justification for what doctors or hospital staff did, which is out of the ordinary. And when your client or the plaintiff might think that it is possibly negligence, a defense could be they did what they did because there was a risk to public health. And then, of course, court orders. If the court orders the doctor, for example, to give a blood transfusion, then, and the person do not want a blood transfusion, but the court orders it, then the patient will not be able to sue the doctors. He will or she will have to go to court and have it looked at why the court ordered the blood transfusion to take place. So any of the above, if they are present, then that will exclude the wrongfulness in a delictual case and unlawfulness in a criminal case. And then there's of course others as well, contributory negligence, prescription, or there's no causation. So we will go into a little bit more detail on all of them. Okay, now we come back, and I've dealt with this in the other webinars as well, but this cannot be stressed enough. The bottom line for medical interventions are informed consent. Why? Because the Constitution, let me just see, yes, because informed consent is based on the principle of the right to self-determination, autonomy, where you decide what happens to your body and what someone can do to you. If a doctor does not have informed consent, it can be seen as assault. So informed consent is extremely important. And I have stressed this many times. You have to go and read the case of Castell versus de Greef. The reference for the case is in your study material, and it was on the previous webinar as well. What is the bottom line of informed consent? It is based on the Latin phrase, volenti non fit injuria, and that basically means he who consents, to him who consents no harm is done. So once you've given informed consent, then you have allowed the operation to take place or the doctor to do certain things with you. Okay, see your study material for the requirements for valid consent. So I'm not going to repeat this. It's in your study material, and I think you know it by now. Just a side note, remember, if the patient signed informed consent, it is not per se valid consent. The person could just have signed. So you have to look at the circumstances under which this person have signed the consent form. I think all of you who has been to a doctor or an emergency unit or whatever, sometimes they just put the forms in front of you and you are required to sign. And those things at the end of the day, when it goes to court, cannot be seen as valid informed consent, because there's a difference between just plain consent and informed consent. For informed consent, you need to be informed of the risks, the pros, the cons, the alternatives in a language and on a level that you understand. Only then can you basically say that you have given informed consent. This is generally now what you need to know about informed consent, and it is highlighted in the case of Castell versus de Greef, point by point. But it is extremely important to add to the general requirements or how we explain informed consent to also look at the legal requirements in the different acts. And I've just listed a few so that you can get used to it, to know that apart from just generally knowing what is entailed in informed consent, go to legislation and see the specific requirements in those different acts for informed consent. In the National Health Act, I think it's sections 6 to 8, that addresses consent. So you have to comply, or a doctor or a hospital have to comply with the National Health Act. When you are dealing with a mentally incapacitated person or a mentally ill person, of course you have to look at the Mental Health Care Act as well. Then I've also said in the previous webinars, children, children, children. Extremely important, and be very careful when you are dealing with a case where a child is involved, because children, they are an exception, and you have to consult the Children's Act. Remember, a children is, according to the Constitution, a person below the age of 18. But according to the Children's Act, 12 is the cutoff. A child of 12 who has the maturity can consent to medical interventions. So you must look at the Children's Act if you are dealing with a case and the child is, for example, 13 or 14. Then remember the Children's Act. When it has to do with pregnancy, abortion, or anything like that, also consult the Choice on Termination of Pregnancy Act. Remember there that a girl child of any age can consent or request a termination of pregnancy. Then you also need to know the Consumer Protection Act, what are the prerequisites there for consent. And just, by the way, just remember, for example, also I'm going to discuss two cases now on sterilization. For sterilization, it is specifically required to give informed consent in writing. In the other acts, it is not so specifically stated that it need to be in writing, but for sterilization, it need to be in writing. Oh, and now the next, sorry. Okay, the cases I want to discuss on informed consent, or which I want to refer you to, is the first one, and it is a patient versus a doctor. So in the first one is Isaacs versus Pandy. It is a 2012 case, and then it went on appeal, and therefore the parties have changed. It is then Pandy versus Isaacs. But these two cases, quite interesting. It concerns sterilization, and the woman claimed that she did not give consent. What is also interesting about these two cases, and why I would like you to go and read these two cases, is because it was a claim based on a contract and delict. So remember, I said your case can be based on the breach of contract or delict or both. So in Pandy versus Isaacs, the claim was on both a contract and a delict. So this woman went in for her fourth child, and before she received a cesarean section, there was negotiations between her and the doctor asked her whether she would like, after the cesarean section, to be sterilized as well. She at the beginning said yes, Then she changed her mind and said no. And then she said she'll speak to her husband. And when she went to the doctor again, she said no, she doesn't want it. The doctor then talked to her and told her that he thinks it's best because it's difficult to have 4 births via a cesarean section. And then she said yes, okay, she will be sterilized. But then what happened is that the nurse did not tell the doctor before the operation that the woman changed her mind and that she does not want to be sterilized anymore. At the end, she was sterilized. She was angry, she didn't want to be sterilized, and then she sued the doctor and said that she did not give informed consent. But the court found the doctor not to be guilty, and the court said that it is actually the hospital staff that were negligent, in that the hospital staff didn't draw the attention of the doctor to the documents or told the doctor that the patient changed her mind. And because the claim was against the doctor, the gynecologist, and not the hospital, then of course the appeal was dismissed. So those 2 cases are very interesting, and I would like you to read it for the sake of seeing contract and delict and to see informed consent, how it was discussed in those 2 cases. Then the one in red, Beekes versus Smith, is a bit more controversial. You will see it's a 2019 case in the Supreme Court of Appeal. And I challenge you, I say it's an interesting case, and you have to decide whether you agree with the judgment or not. There has a lot been written on this case in the academic literature, in the law journals, where people disagreed with the judgment given. Well, the case is basically about a woman that had perforated something in her bowel was perforated, and she had to go in for a procedure. But she was extremely obese. And then when the doctor started the one procedure, he saw that it will not be beneficial to the patient, and he moved over to another procedure. The one was a laparoscopy and the other one a laparotomy. So there's a slight difference between the 2. It is discussed in the case. And then he did the one. He chose the one procedure, and then afterwards the woman had a little bit of problems and she needed more medical attention. And then she came forward and she sued the doctor because she said she did not give informed consent because the 2 procedures were not explained to her in detail, and she couldn't decide which one was the best. The doctor did, and she disagreed with him. But the Supreme Court of Appeal found in favor of the doctor and said the doctor had informed consent, and that he had told her about the pros and the cons and the risks of both, and therefore the appeal was dismissed. What is very interesting in that case is that the doctor made the remark that he got informed consent orally, but yet he could not prove that he got informed consent and that he actually explained everything to the patient, yet the court accepted that. And that is why I always stress to you, and I should actually preach to doctors and hospital staff, if it is not written down, it did not happen. But in this case, the court favored the doctors with the doctor's testimony, and when he was called as a witness, when he said that he in fact did get oral informed consent. So that is why I say it's a little bit of a controversial case. So you can read it, as I say, it's 2019, so it's quite a recent case. And if you Google it, you might come across some law journals where legal experts have criticized the case. Okay, so what is informed consent? Just sort of to summarize, sufficient information must be supplied by the doctor. The following cases concerns the negligence of a gynecologist. I think I told you about this in the previous webinar. Sorry, I'm just drinking water. And please excuse me if I repeat myself or I cannot remember. And I'll tell you why. When the corona happened and there was a lot of issues with how to do the webinars, etc., I went into Leeds offices one day and we recorded all three the webinars, only to find out afterwards that it actually did not record. So I had to do it all over again, and the first one I did while I was on holiday in Cape Town, and the second one I did one morning at 4 o'clock so that the house is quiet. And now I'm doing this one today. So I've spoken so much about the content that I don't know whether I've told you this or not. So please pardon me if I am repeating myself. Also keep in mind that I am older and don't remember everything. But I think it's always good to repeat certain things so that you will never forget that. Okay, so informed consent when a gynecologist is involved, and there you have to distinguish between unwanted pregnancy, wrongful birth, and wrongful life. Unwanted pregnancy is when you went for either a vasectomy or a sterilization, but it was not done. So you gave consent to be sterilized, yet the doctor did not do it, and you had sex afterwards and you fell pregnant again. Then it is what we label an unwanted pregnancy, and you will sue the doctor for negligence. And if it is proved, then the doctor will have, or not the doctor, him or herself, it's usually their insurance, will have to pay for the upbringing of that child that is born after a botched sterilization. So that is quite straightforward. You did not give consent to fall pregnant again. The doctor didn't do what he said he will do. You fell pregnant again. There is a child to be raised. There are costs involved, and you will claim those upbringing costs. Wrongful birth is where you go to a doctor and you ask the doctor specifically to check whether there is something wrong with the fetus. In other words, they must do certain tests to find out whether the fetus is normal or not. Usually this is very important when you are either diabetic or obese or an older woman. Then there are certain dangers. And then usually the mothers go for extensive tests to check whether the baby is normal or perfect. Otherwise, if, for example, the baby could possibly be a Down syndrome baby or have spina bifida or any other illnesses, then the mother would want to rather have an abortion. Now, if the doctor then do all those tests, but then interpret it wrongly and tell the woman that she is expecting a normal baby, yet that is not the case, and then a disabled baby is born, then the parents can sue the doctor because of the negligence of giving them the right information, because if they had the right information, they would have aborted the baby. That is then the parents that institute that action, and that is called wrongful birth. They do not want this disabled baby, or they want the costs. They want to be reimbursed for the costs that goes with a disabled baby, And then if they are successful, the damages will be paid out to the parents so that they will be helped with raising this child with the special attention that that baby need. Those two actions are completely lawful in our legal system, and it happens quite often because especially in the public sector where they do not do the sterilizations perfectly, or they do a cesarean section and they forget to do the sterilization, then you can have that claim unwanted pregnancy. Or in the public sector, they don't do the test, or they don't warn the mother of a disabled child, and then afterwards a claim is brought. Okay, so those are well known in our legal system. The last one, wrongful life, that is new. And for many, many, many years, if you read the Friedman and Glickman or the Stewart versus Botha case, you will see that wrongful life was seen as contra bonus mores, or against the public opinion or public feeling. Because under that claim, it is the child that institutes the claim. Of course, he or she is helped by the parents, but it is the child, him or herself, that say, I should never have been born. So, but for the mistake that the gynecologist made in the interpreting of all the tests, I would not have been born. Now I am born, I am disabled, and I am suffering. And the child then claims damages or money so that his or her life could be better. Now, for many years, as I've said, that was not allowed. And you can see Stewart versus Botha, Supreme Court of Appeal case. And in that case, it was once again that you cannot compare a disabled life to no life at all. And therefore, they did not entertain wrongful life claims. But then in H versus the Fetal Assessment Center, they went to the Supreme Court of Appeal, and they asked the Supreme Court of Appeal to look at wrongful life claims again and to develop the common law so that you can go to a high court on the claim for wrongful life so that the child can institute that action. And it was granted in the Supreme Court in the Constitutional Court. But remember that the Constitutional Court only developed the principle. They did not adjudicate the case. So H versus Fetal Assessment Center must go back to the High Court and now claim on the basis of wrongful life, and a whole new case will start, and it needs to be proved that this child is suffering. Wrongful life is also meaningful because the Constitutional Court now allows for it if prescription happened, because that is exactly what happened in H versus the Fetal Assessment Center. The child was already 6, more or less 6 years, when his parents got to know that they could actually institute an action. Now, when does a case prescribe? And we're going to address it now. Within 3 years, although children are different. But the case from the parents' side prescribed within 3 years. So they could not go to court on the basis of a wrongful birth claim. So the only option they had was to go for a wrongful life claim. So they went to the High Court, but then there was an objection from the Fetal Assessment Center, and they said that there was not such a claim in our legal system. And that is why they went to the Constitutional Court, and the Constitutional Court said, yes, a child can now approach the court on wrongful life, and yet the facts must prove the case. So the Constitutional Court did not make it a blanket acceptance. the facts of the case must still prove it. Usually when I just give the webinar that is either recorded or we don't see each other and it's not on Teams, I break at 5 o'clock for 5 minutes, but I think I'm going to carry on, and then afterwards we can have a discussion, or those of you who are in a hurry can go. So I'm just going to carry on.
I'm so sorry to unmute myself.
No problem. Yes.
There's about 2 or so candidates that are saying that they are awaiting you to accept them. I think they've been having a problem for about an hour waiting to be accepted. I'm not sure if you saw that.
Okay, I've opened that now. Let me see. Oh, so they missed nearly everything. Okay,
yes, they've missed about an hour.
Yeah.
Okay, thanks.
Let's see another one. Okay, are they all there now? I hope so. Yo, sorry people that waited in the lobby. I don't know why the system does this, but welcome to those of you. We are nearly halfway, but as I've said, you will get the slides. So you will get the slides, and okay, you will not hear what I said about it, but you will get the slides. If I can just quickly, just for the sake of those that were in the lobby, I addressed the administrative matters. I've shown you a picture of me and Bonnie. I said you must not throw in the towel and try your best with your portfolios. I've summarized what we did previously. I alluded to the mediation, the change of the High Court rules. And I've spoken about those 2 cases. It concerns cerebral palsy of a baby, and I said it's changed the medical law field, the once and for all rule and the lump sum payment. So definitely go and read these 2 cases. Then I've just summarized the grounds of justification. I've spoken about informed consent, which is also in your study guide. And then I spoke about these 2 cases, quite recent cases on informed consent, and the one in red, which is controversial, that you can decide for yourself. And then I've spoken about unwanted pregnancy, wrongful birth, and wrongful life claims. Okay, that is where we are. Let me just quickly go and see, are there any more? It doesn't seem like there's any more in a lobby. Sorry about that, but yeah, this is all new to us. I thought you will automatically get in. I didn't realize I must let you all in. Okay, so another ground of justification is when there's an emergency. And those of you who have studied the law, you will know the term negotiorum gestio. That is where you take charge of someone because it's an emergency. So you do not need the consent of the patient. The patient is unconscious, either in a coma or a shock, and it is life-threatening, and then you just take control and you do whatever is necessary to that person, and that person cannot turn around and say or sue you for negligence because the person took control of you under negotiorum gestio. I think, I'm not sure, so just bear with me if I've spoken about it. A do not resuscitate is not a valid thing, or they will still resuscitate you. Because if you have a do not resuscitate, either bangle or even a tattoo, the emergency workers will have to do what is necessary because they cannot make a diagnosis. Okay, I see someone is showing a hand. Are you putting up your hand?
Yes, ma'am. There's one more who's still in the lobby.
Eish, why are they so late? Okay, I'm admitting them. Let's see. And another one. Okay, so if someone contacts you and they're still in the lobby, do as this participant did. Put on your video and show me a hand. Then I will stop and I will let them in. There's still more. Sorry for that, but we have a lot of time still. There's another one. That one doesn't want to go in. Okay, excellent. Draw my attention if you see someone wants to come in. Okay, so I'm busy with the emergency. Then they can also do blood transfusions. Blood transfusions is an exception. Take note of that. You can read Hay versus B, but that happened before the Children's Act. Now the Children's Act overruled Hay versus B. Phillips versus de Klerk. Remember, if you are an adult, in other words, above the age of 18, be careful, Children's Act, above 12 of maturity, then you can refuse a blood transfusion. But if you are in a coma or in a shock or it is life-threatening, then a child whose parents refuse a blood transfusion because the parents are Jehovah's Witnesses, that will now be overruled by the best interest of the child, as is in the Constitution and the Children's Act. For grown-ups, a little bit more difficult. Let's say we are Jehovah's Witnesses and it is life-threatening. I might die or whatever. Then they will ask my husband, or I have to indicate a person beforehand as my sort of curator that will take decisions for me medically when I am not in a state to do that. The ES versus AC case is a Namibian case and it concerns blood transfusion of a Jehovah's Witness. So it's also a quite recent case from Namibia, and remember that our constitution say that we have to take cognizance of court cases in other countries, so it's quite interesting to read that Namibian case. Let me just I heard a thing. Okay, there's no one there. Okay. May a doctor deviate from a procedure? And the short answer is yes, under specific circumstances, if it can be proved that the health was improved. In other words, I go for a hysterectomy where they have to take out everything, so the uterus, so that I cannot bear children anymore. If the gynecologist then, while the operation is busy taking place, then decide to give me a tummy tuck, in other words, to cut out the fat in my tummy, that is a no-no, and that could be possibly assault, because I did not give informed consent for a tummy tuck. I gave informed consent for either a hysterectomy or a sterilization. So he deviated. He did not have informed consent, and I will be able to sue him or her if that is the case. But let's say I go in for a biopsy and they find out that my liver there's cancer, there's some or other thing in my liver and it's cancerous. And when they open it up, they were only going to cut out a part of the liver, yet when they open it all up, they see that it's a part of the liver, but it has also moved into my kidneys. Then they can take out the kidneys as well, because they will be improving my health, although they only had informed consent for the liver. What is best to do for doctors is to get informed consent from the start, saying that if I open you up and I see that other organs are also infected, do I have your consent to proceed and remove it? Then that is no problem. But if you go into for anesthetics and the anaesthetist discuss an epidural with you, and then eventually in theater decides to do a spinal block, that is a no-no, because you gave permission for an epidural where the specialist followed another procedure, and you did not give informed consent for that. Okay, before I go to the next slide, I'm just quickly going to see there's another 3 people. Let me just admit them. I push on admit all and sometimes they don't want, but at least I'm writing in the lobby. Okay, let's carry on. Contributory negligence, we've discussed this previously with the Dubé, the plaster on the arm, that the arm was swollen. He didn't go back soon enough to the public hospital, and then the arm had to be amputated. But then the court said there was no contributory negligence because Dubé did not understand, and the hospital did not explain to him when and how soon he must come back. So you can just take note of that case. I want to focus now on prescription. Prescription, and especially if you are an attorney's firm and you appear on behalf of the plaintiff, the defendant, they love to go and say, yeah, but prescription. So make very sure that you understand what is meant with prescription and how it is applied in a medical law scenario. So where do you start? Of course, with the Prescription Act 68 of 1969. And then I refer you to that loose leaf book, Medical Malpractice in South Africa. It was written by John Sainer, Senior Counsel, and it is published by LexisNexis. It is quite expensive, but extremely valuable. If you are at a firm or you are going to practice in the medical law field, I will say that is a must because it's very practical. Remember, this course is just introduction to medical law. So I do not even touch on all the documents or all the processes that you need to follow, the particulars of claim, the notice of intention to defend, all those things. We do not even touch on that. But that is very nicely put in that loose leaf Medical Malpractice in South Africa. That will help you a lot with the actual documents and how to go about running a whole medical law case. Okay, now back to prescription. A debt shall not be deemed to be due until the creditor has knowledge of the identity of the debtor and of the facts from which the debt arises, provided that the creditor shall be deemed to have such knowledge if he could have acquired it by exercising reasonable care. Now, that is what the laws say, but you should read, and I've put exclamation marks there in red because I find that specific case of Trutter extremely sad. Now, you will see it is 26, so it's quite a while ago, but it was in the Supreme Court of Appeal. Now, poor Mr. Duisel had a lot of operations on his eyes. And he eventually went blind in the eye, but he couldn't get an expert. He couldn't get an expert who is willing to say that the reason why he lost his eye was because of all these operations that was negligent. The doctor that operated on his eye was negligent in that he did too many operations. He should have known that the result of all these operations will be that he will lose his eye. But he couldn't find an expert willing to say that. So there was a lot of back and through attorneys' firms, and they couldn't find a doctor or an expert, and the time started running. And then eventually, this person heard a radio program, and an expert was speaking over the radio, and that person was contacted. And that person looked at all the doctor's reports, at all the medical records and everything, and that person said he will come forward as an expert because the person who did all those operations was negligent. Okay, so the action was instituted, but then the defendant came back and said, no, 7 years has lapsed. But the counter argument was that Mr. Duisel, it took 7 years to find an expert to come and say that there was negligence. Now, if we go back to the previous slide and said a debt shall not be deemed until the debtor and the facts, it's there, that the facts are there. And you must take reasonable steps to determine the facts. And the plaintiff said he tried everything, and he even submitted every time that he tried to find an expert, he submitted it to court. But the court said, no. The moment he lost his eye, from that time, prescription started running. And therefore, the case was moot and it was dismissed. It is extremely sad because I have told you from the very beginning, you cannot win a medical law case unless you have an expert willing to come and testify that the person accused of the negligence did not act as a reasonable person, doctor, specialist, nurse. So that is sad. And then all of a sudden comes the case of Links, and it went to the Supreme Court of Appeal in 2016. And he dislocated his thumb, and his thumb was eventually amputated, and a prescription started running, and they were out of the 3 years. Yet the Constitutional Court said, no. When and he was not a very literate person, when he realized something went wrong, only then did prescription start running. So it is two cases. I will not say they are opposing each other. I think the 2006 case was not judged 100% correctly, but it was corrected in the constitutional case of Links. It is just sad for Mr. Duisel, who could not succeed. And then the other one you can just read, that is a child who got older and then started instituting, and she was a passenger in a car and she was only 14, and then she instituted action when she turned 21. And that is just a case that indicates that thing. Remember now, and that is why I've noted it there at the bottom. Prescription only commences when he or she reaches the age of 21. If you go to that McLeod versus Cuellar case, remember that the age of majority in that case was still 21. It has since been changed to 18. So prescription only commences when a child reaches the age of 18. He or she will then have 1 year from the date of his or her 18th birthday within which to institute action. So remember that. And that is why I said in that wrongful birth actions, where the parents instituted, they have to do it within 3 years. But if the child institutes the action on a wrongful life claim, then they have until the age of 18. And that is why in that age versus fetal assessment case, the child was 6. So the child could institute, even though it's longer than 3 years. But because it's the child, that institute the action, the parents are just assisting. That still, that did not prescribe. So remember that. Okay, now, one of the requirements to be successful with a medical law case is that you need to prove the damages. But sometimes you can sue the doctor and the hospital. Remember, doctors in private hospitals and nurses in private hospitals, be careful, find out before you decide who's the defendant. Doctors in a private hospital, they are always independent contractors. Nurses, they either are employees of the hospital or they work for a contracting company that supply nurses. Be careful, find out that when there's damages that was suffered in a hospital, whether you are going to sue the doctor and the hospital and the nursing staff. So rather put all of them, then they have to come and show why they should not be part of the claim. But yes, in this case, for interest's sake, you can read that the hospital at the end of the case was 40% responsible for the damages and the doctor 60%. And there I just refer you to the Apportionment of Damages Act. And then you also get certain books that help you with how to determine that. If we think back about that Isaacs versus Pandy case, can you remember? It was said that the doctor was not guilty of not having gotten the informed consent from the patient, but the judgment said that the medical staff was actually negligent. So maybe if she sued the doctor and the hospital, she would have gotten something, but she only listed the doctor as the defendant and not the nurses who did not give the message to the doctor. So just take note of it and make sure when your client sits in front of you and whether you should sue the doctor, the hospital, the nursing staff. Completely different scenario in the public sector. There they are all employees of the Department of Health. And remember that health is provincial, so you will sue the head of the province, the MEC for health in that province. Sometimes I see they even add the premier of the province as well. But remember, in the public sector, they are all employees, and that is why you do not sue them individually. Okay. Then in your study guide, you will see there are certain statutory matters being addressed. This is more or less a sort of a summary, so I'm going to go quickly through that. Remember, at this stage, South Africa has a private and a public sector. I've spoken a lot about that, so never forget that. First of all, establish where did the alleged negligence happen, in the private sector or in the public sector, or in both. Because sometimes a private patient will go to the GP, and then when they need tertiary care, they will go to a state hospital. So make sure where did what happen. Remember, we do not have national health insurance yet. Sorry, I just heard a click again. Let me just see whether I can admit and admit. Okay, sorry for that. The NHI is not implemented yet. And I might add that myself and a colleague of mine, Professor Melody Labuschagne, she used to be Professor Melody Slabbert, we have written a book on the national health insurance. It will be published in a few months' time through JUTA. And there we analyzed the national health insurance. But remember that if everything goes according to plan, if government finds some money somewhere, national health insurance will only be 100% nationally in South Africa in 2026. But keep that at the back of your mind because there are pilot projects, etc. And start wrestling with the thought, who will you sue? If a person contracts into the National Health Insurance, a doctor, yet he also has a private practice and things go wrong, will he be seen as an employee of the NHI or not? So there's a lot of things that have to be sorted out, but as I said, only in 2026. That is the envisaged date for national health insurance in South Africa. Okay, then remember, you always start with the Constitution. Always start with the Constitution, always in the background. Something went wrong with your patient, with your client, check. Was any of his or her human rights violated? The right to dignity, the right to life, the right of access to health, the right of self-determination. Then also look at the National Health Act, because this is one piece of legislation covering the whole spectrum of healthcare in South Africa. The Health Professions Act, that indicates how and where doctors need to register, what are the requirements for their registration, and what should happen if they then act unprofessionally. And every person that falls under the Health Professions Act must be registered by the HPCSA, the Health Professions Council of South Africa. But remember that nurses do not fall under the Health Professions Council of South Africa. They have their own nursing council and they have their own act. Same with the pharmacist, they have their own act. So depending on your scenario, what happened, remember, you start with the Constitution and then you go to all these other acts and check how relevant they are. Then remember that pregnant women and lactating women and children below the age of 6, they are entitled to completely free healthcare. It's very interesting. All of us assume that healthcare in the public sector is for free, but that is not the case. You pay a certain amount according to your income. So in other words, if you register as a patient in the public sector, you will have to take your ID document and a payslip or a letter of your employer. How much do you earn? And then according to a scale, they will tell you you have to pay a certain amount in. But for pregnant women and children below the age of 6, it is completely free health care. Then just remember, I said this in the first webinar, in cases of emergency, when it's a life or death situation, a private hospital should stabilize a patient at no charge and then move the person to a public hospital. And I want to leave a thought with you. I do not have the answer yet, but I feel it is worth thinking about and maybe investigating or whatever the case may be. In this COVID time, I know of a person whose father got a heart attack. So they rushed to a public hospital because they did not have medical aid. When they arrived at the public hospital, they were told that they cannot accommodate him because they are now focused on COVID-19. So they said, sorry, they cannot accommodate him. But the family said, but it's an emergency. And they said, sorry, they can't. So they drove to another public hospital. Same scenario. It's not COVID-19 related. It's a heart attack. Therefore, they cannot accommodate this person. Eventually, the family took him to a private hospital, who then accommodated this father, this husband. And then they were only supposed to stabilize him, and then he had to move to a public hospital. But they couldn't stabilize him. He was so badly, I can't say injured, but the damage was so terrible that they had to keep him in ICU for 7 days. and then only he was stable enough to be moved. And then the hospital gave the family an account for this person in the ICU for 7 days, and it was over R1 million. And they had to sign that they will repay this public hospital. I feel differently. I feel that it could be challenged. Why? These people did not have a medical aid. They were turned away by 2 public hospitals. The private hospital knew they did not have medical aid, and there's a duty on private hospitals to stabilize a person before moved to a public hospital. The family or the person, the patient self, is not responsible for the fact that he was not stabilized or could not be stabilized. The worst case scenario from my point of view is I will keep the state responsible for the bill because I was turned away at 2 public hospitals. And if I wasn't turned away, the public health would have helped, yet they turned me away at 2 instances. I had no other option. It was an emergency. I had to go to the private hospital. So the family are still thinking what to do, but I feel it is worth challenging. I don't know what you feel. You can talk to me later. Okay, then I've said, apart from looking at the Constitution and all the acts, always remember to go to the website of the HPCSA, and they have certain booklets where they go into more detail. Remember, the booklets are, it's not law. It's not law, but it is guidelines. And it is accepted by everyone within the profession. In other words, because of that, it gets some or other power to base your arguments on these booklets. As I've indicated, the numbers may differ because they sometimes add. And what is interesting, I know they've now added one on e-health, because that is another thing that is now coming forward, is where you are diagnosed electronically and what could be the negligence there. So there's an HPCSA guide now on telehealth or telemedicine. So quite interesting. There might be cases someday about that. Or you can also consult the website of the South African Medical Association, SAMA. Remember, the other one that I referred to is SAMLA. SAMA is the South African Medical Association. It's a voluntary association, but there's a lot of information on their website. And then, of course, when it is the nursing staff, then you will go to their website because they've got their own controlling body. Okay, what is the relevance of the HPCSA? Now, sometimes a patient will contact me and say, give me briefly background of what happened, and then will ask me, can I refer him or her to a lawyer, and what will the costs be, etc. Now, yes, it can go on contingency. Some lawyers do not work on contingency, and some patients do not have the money to sue or for litigation. What are the options then? And the best thing is you go to the HPCSA and you report. You report the alleged negligence or the unprofessional conduct of the doctor to the HPCSA. Of course, everyone that is registered by the HPCSA, you can report it there. If it's a nurse, then you have to go and report it at the Nursing Council. But it basically works on the same principle. So in other words, if you do not want to start civil action, report it to the HPCSA. You will get very good guidance on the website of the HPCSA how to report it. Necessary forms to be filled in, necessary affidavits, and you have to tell your story, etc. But it's worthwhile. Unfortunately, the HPCSA is not so on top of it these days. It might get better, it might get worse, but it is worthwhile. If you are angry about something that happened, go and report the doctor, the surgeon, the specialist, whatever, to the HPCSA. They are then forced, it is legally compulsory, to do a disciplinary inquiry about unprofessional conduct. And then, if it is something small and obvious and not that serious, then there's an ombudsman. And the ombudsman will take a decision and let you, as the patient, know about the outcome, and then the matter is settled. If it is more serious, then there will be an initial inquiry about what happened. And then when there's enough evidence and there's clearly unprofessional conduct, it will move over to a disciplinary hearing. If you as a doctor, of course, audi alteram partem, to listen to the other side, so the patient will have the opportunity with a legal representative to state his or her case, and so the doctor, the surgeon, or whoever is being accused will also be able to state his or her case through legal representatives, and then a decision will be taken. If you are not satisfied with the decision of the disciplinary hearing, you either as the patient or the doctor, you can appeal to an ad hoc appeal committee. And if you're still not satisfied with what they decide, you can go to the High Court. You can ask the High Court for a review. In other words, the High Court will look at all the documents, listen to the transcription, and then come with a judgment. But if you're even not satisfied with that, you can go to the Supreme Court of Appeal. And all of this is then not necessarily for your cost. I mean, to go to the HPCSA and report unprofessional conduct is costless. It will not cost you as a patient anything. Once it is established that the doctor acted unprofessionally, the HPCSA will take it from there. And then if the doctor is not satisfied on his cost, he will then appeal. So the patient will only notify the HPCSA of the unprofessional conduct and will be called as a party in the disciplinary hearing, but then afterwards it will go on and on via the HPCSA or the doctor who's then found guilty. The best case that I can refer you to, and it's a Supreme Court of Appeal case. So in other words, it went all the way. It ended up at the Supreme Court of Appeal, is the case of the Health Professions Council that was before it changed its name, versus De Bruin, 2004. That is a sad case. It's a sad, sad case. Worthwhile reading so that you understand the whole process of the controlling body of the people registered there, and see for yourself whether you agree or not. But it's a very sad case. It is a doctor who wasn't a doctor yet. He was still a medical student, fell in love with another student. She fell pregnant. They didn't want a baby. He gave her things to drink so that she would abort the fetus. The fetus did not abort. He eventually put equipment into her vagina to get rid of the fetus. He left her to drive home alone. After he has done that, she got home. There was still a part of the fetus within her. Then he didn't want to get married to her. She eventually developed psychological problems, and she spoke about this whole thing. And then he by then had become a doctor, and therefore he went through a disciplinary hearing, was found guilty, then appealed, and it ended up in the Supreme Court of Appeal. Sad, but interesting from an educational perspective to see how the process works. And then if you are working with road accident fund cases, I just have an article there that myself and a neurosurgeon have written on the appeal process if serious injury claims are rejected by the Road Accident Fund. It is published in Obiter, that is a law journal of the Nelson Mandela University. It's not open access, so those of you who would like that article, just send me an email and I will send it to you. Okay, then other laws referred to in your study guide. Remember, as I emphasize children, the Children's Act, remember when you're dealing with a mentally ill person or anything around mentally ill, that it's a mentally ill person who was incarcerated on not voluntary or whatever, then you have to take the Constitution, the National Health Act, but also the Mental Health Care Act into consideration, and they specifically have review boards that will look at what happened with a mentally ill. So that is a very specialized field, so I'm not going to go into detail. Just remember, when you are working with a mentally ill case, to consider that act and the review boards. And then, of course, we have the Consumer Protection Act. I hope you remember the Athrox case, the indemnity clause. And I've said to you that the Athrox case is still the precedent that said that the indemnity clauses are valid. It has not been challenged yet. All of us in the medical law field are hoping that someone will challenge indemnity clauses of hospitals based on the Consumer Protection Act, because then the Athrox case may be overruled. But according to the Consumer Protection Act, the patient is a consumer and the service is the treatment of the patient. And there are 8 fundamental consumer rights. You will see that it overlaps with the Constitution. Everyone is equal before the law, privacy, in other words, confidentiality, autonomy, the right to self-determination, it goes over to informed consent. But what the Consumer Protection Act have added is that the doctor should also now tell you about the risks of equipment. For example, if the doctor is going to use donor bone or a pacemaker or prosthesis for breast enlargement, apart from explaining to you the risks and the pros and the cons of the actual operation, he must now also inform you of the risks of the equipment that he's going to use. Because according to the Consumer Protection Act, you can sue everyone in the whole chain. So just look at the third bullet from the bottom. The patient now suffered damages. So the patient can sue the doctor. Let's say a pacemaker was put into your heart, but it's defective, and now you have suffered damages, and now machines must keep you alive or whatever. Then the patient can sue the doctor, the retailer, the distributor, the importer, and the producer. Now, what is the most easy one to sue? The doctor, because that is the person that you know. If you got breast enlargements, you will not know who is the importer or the producer or even the distributor. But according to the Consumer Protection Act, you can now sue all of them. When there's a dispute, it will go to the National Consumer Tribunal, and there's a National Consumer Commission. So you will go to those first before it eventually ends up in court. And then please take note that the POPI Act, the Protection of Personal Information Act, became effective in July this year. And hospitals and companies and everyone has 1 year to comply. So this just once again underlines confidentiality. But in a hospital scenario, it is still difficult, and we are speaking to the regulator to have certain exceptions, because personal information is nearly everywhere in a hospital. From the moment you are admitted, then it goes onto your file, but it's a specialist and a doctor and a nurse and the people coming to pick up the blood. They all have your information. So there will eventually come more guidance on how the POPI Act should be applied in a medical or in a health scenario. Okay, as I've said, that the exercises are for yourself, and then I just note there an interesting case, a case from Singapore, ABC versus Thompson Medical Limited. You can go and read it yourself. Very, very interesting. There you will see how it is based on the basis of contract and the basis of delict. Basically, it is a Caucasian man and a Chinese woman who could not conceive naturally and then went to a laboratory for in vitro fertilization. It was her egg and his sperm. They were fertilized and then placed back into her uterus, and they conceived a beautiful young boy. 5 years later, they went to that same laboratory because the laboratory still had the eggs freezed and the semen freezed, and the same process. But then when the baby was born, it was a very dark Indian looking child. And then eventually they realized that there was a mix up with the sperm. And then the husband and the wife sued the laboratory on the basis of contract, and damages were awarded. But they also sued them because they wanted a child, but they didn't want that child. They wanted a child that is genetically linked to both the mother and the father. Now they had a child that is only linked to the mother, but biologically not linked to the father. Very interesting. Go and see what the judges or how they handled that case. Thank you. I have spoken a lot, so yes, here I am now. Any one of you can ask a question. I'm going to unmute all of, well, you can unmute yourself. Oh. Okay, anyone with a question? Then just unmute your mic, and if you want to, you can put up your video and then you can speak to me.
Hello, ma'am.
Yes.
I just want to ask a general question. I'm thinking more along the lines of labor law. So when we have a medical law case and we allow people to bring a matter in terms of delict and contract, doesn't that allow for forum shopping? Because, I don't know, I'm just thinking in the labor law context that you'd have to choose one course of action. So isn't it, if we are allowing people to bring on in terms of contract and delict, then it's sort of like allowing people to take as many shots as they can to potentially make a win.
Okay, I hear what you say, and a good question, and that's why please go and read that Singapore case, that last case on the slides. It depends on the specific case. Remember what I've said. And you can also go and read, I'm thinking now, and I'm old, but go to your study guide right at the beginning. It's the Edward case. That was where a sterilization was not done perfectly, and the baby was born, and they were sued on the basis of the contract. But remember, then you cannot claim non-patrimonial damages. So you cannot claim pain and suffering. You can only claim actual costs. So basically, to answer your question very shortly, and you will see in all medical law cases now that you will read, it's all based on delict. It's all based on delict because of that, because then they can claim patrimonial and non-patrimonial damages. But in the Isaac Pandy case that I referred to now, there was contract and delict. So it is a choice, but in practice, it's mostly delict. That Singapore case was contract, and they got contractual damages for the negligence of mixing up the sperm, and an amount was given. But they went on delict for the fact that a child was born, a child that they didn't expect. But yes, I hear what you say, but the majority, or I can nearly say 99% of medical negligence cases will be based on delict.
Okay, thank you very much.
Anyone else?
Yes, okay. Hi, thank you, Magda.
Yes.
I think my question, I don't know if it takes us a bit aback, but it relates to maybe negligence that results in ultimate death. Who are the potential claimants in such an instance?
Okay. When there's ultimate death, it can only be the people dependent on the person that have died. For example, if a husband dies in hospital, the wife, she can then claim because he supported her. But they will look at what she earns and her earning capacity versus what he earned and how much he contributed to the joint household. And that will be the damages that she can claim. Remember, right at the beginning, I told you that if I have a son, a student of 19, and he dies because of negligence, I have no claim. Because who has suffered damages? He's dead. He was not supporting me. He didn't have children. No one can claim. That's just sad. But if he's not dead, but a paraplegic, then of course you have a huge claim. So yes, the next of kin can claim. If the person is not married, the children can. If the father supported the children.
Okay, so effectively it looks at also a person who's self-supporting, like for example, as in RAF cases, a person who's maybe over 18 or maybe self-supporting, or a person who's not dependent on the parent can't necessarily claim if the parent is the one that dies.
The self-supporting person older than 18 dies, but that person did not support any person, then there's no claim. Remember, you must prove who suffered damages because this person died. And you have to quantify your damages.
Okay. The way I'm looking at it is not necessarily if an 18-year-old dies, but if a parent dies of a person who's 18 and above, but who's not necessarily dependent on the parent. Pardon?
Yes. Okay, she's an
not
adult.
necessarily dependent, yes, but there's non-patrimonial loss there, if you you can actually say it that way.
Okay, so the child is above 18, but the parents were still supporting her. That can be claimed. Her pain and suffering cannot be claimed.
Okay.
Okay, that's just sad. That's just sad. You cannot claim pain and suffering in damages if a person died.
Okay.
Okay.
All
so
right. Okay.
pain and suffering only comes when a person is disabled or something like that. But yes, if your parents die, you cannot claim pain and suffering. If your child die, you cannot claim pain and suffering.
Okay, all right. That's very, very sad. Thank you.
That's very, very, very sad. But yeah, that's life. Death is part of life. But yes, it's sad. But it's reality.
Okay, thanks.
Okay. Anyone else?
Yes, Magda. Thank
Yes.
you for your fantastic webinars. Are there any specific legislations or guidelines for COVID-19 related matters?
But the best you can do at this stage is to go to the website of the World Health Organization. Because we are a member of the World Health Organization, we follow their guidelines. As to what's going to happen with negligence that happened in COVID-19, some people say there should be a blanket indemnity for doctors and health workers because of the circumstances in which and under which they work, but no decision about that has been taken, and I think it will need to be addressed case by case.
Okay, thank you so much. But otherwise,
I will just add there. Let's say, for example, because they called retired doctors back, and they called up, for example, dentists to go and work in wards. If something would go wrong there, remember the test will still stay the same. How would the reasonable retired doctor under those specific circumstances have acted? So it is not, you cannot excuse them for blatant negligence, but you will look at the scenario and ask the question of the reasonable person within that specific circumstances.
Thank you. So
Okay.
well, I can't think of any case right now, but is a fallback position, apart from the scenario you sketched, is a fallback position exactly the same as it is, all the National Health Act, the Medical Practitioners Act,
Yes.
etc. Okay.
Yes, of course, within the circumstances of COVID. Yes.
Yeah. Thank you.
Yes.
Thanks.
Anyone else?
Hi, ma'am. I basically have a question with regards to prescription.
Yes.
So with regards to the Prescription Act, you said as well that prescription starts running when the conduct actually, well, in this instance, when the negligence actually occurred.
Yes.
But what happens in the case where someone isn't aware that they have a claim for negligence, and therefore the time actually moves on, and they only realize, say, maybe about 2 days after the prescription while the matter prescribed. What is the stance in terms of people actually pleading awareness counter to the prescription, a plea for prescription being raised? What's the stance with that, and how likely is it for a matter to succeed if someone actually pleads awareness as a defense?
Okay, if you go and read the Link case, the Constitutional Court case, I think that will give you the clearest guidance. But apart from that, the Constitutional Court allowed it in that instance. I think it will also be case by case. Remember, the Act said the reasonable person, what efforts did he or she make? Now, if you read the Links case, you will see that it was an uneducated, illiterate person. And therefore, the Constitutional Court was softer or accepted it more. But if you are a well-educated person, your excuses will be less accepted. So it will depend. And the state, and I say this with respect for all of you working for the state always take chances and plea prescription. But then it is up to the plaintiff to come with the other side and give the facts of why the person did not institute it in time. On the other hand, if I can be nasty to private sector as well, some attorneys leave the case or forget about the case, and then a day or two before wants to quickly get things done. There's a specific case, I think webinar 2, when I gave you that list of court cases. Go specifically and find a case of the attorneys of Crano attorneys. They made a mess. In one case, they forgot to follow up, and then things prescribed.
Okay. Thank you very much, ma'am.
Okay. Anyone else?
Ma'am, I also have another question. With regards to the webinar in itself.
Yes.
Taking into account that some people actually joined in like an hour later, will a recording be available on forums or on the webinar tab page for us to access it from the beginning?
Okay, that is not a decision for me to take. It's a decision that LEAD will take, but I know their feeling is that we do not want to distribute the webinars because then the people do not attend it and they just get it as you get the slides. But this, I am willing to argue with Grace because this is an exception and this is the last one. So I can't see why not. So I will speak to Grace and see whether they will make it available.
Okay,
I've got no objection. So if it's for me to say, I say make it available. I will just clarify it with Grace.
Thank you very much. Where can we get your email so we can get that article on the Road Accident Fund?
Okay, my email address is my surname is Slabbert, so it's SLABB, and then you stop. So it's an abbreviation of my surname, and then M for Magda or Magdalene at UNISA, University of South Africa, UNISA.
Okay.
.ac for academic.
Okay.
.za. But if you Google me, you will come across an article and you will find the email address there as well, or you just contact Grace and Grace will give it to you. She has the right to do that.
Okay. Thank you very much.
Okay, nothing else.
Grace. Hello, it's Grace.
Grace.
Yes. Maybe for this webinar we are going to make an exception, but remember that whenever there is technology, anything can go wrong. But if everything goes according to the plan, the webinar will be uploaded by end of day tomorrow.
Okay. Thank you, Grace.
Thank you, Grace.
Okay, if there's no more questions, then good luck with your last portfolio and congratulations to all of you that's going to get good marks. As I've said, this is a difficult module and we expected a lot of you, but be proud of yourself. Okay, then good night. Enjoy the evening.
Thank you.
Oh, thank you.
Bye.
Bye.
Thank you.
Bye.
Bye.
Anne.
We need to have it stored flat to the surface to ensure that we don't get bubbles in it